Good morning again, and I'm delighted to open the panel dealing with international developments in class actions and collective redress. And let me start with a smile. Retired Chief Justice Grunis mentioned greed on the side of plaintiffs' attorneys, and no word about greed on the side of attorneys on behalf of the defendants. As a lawyer dealing with defendants for the last 30 years, I think this comment should be emphasized. And now to our first guest, Professor Rhonda Wasserman. Rhonda is a professor of law at the University of Pittsburgh School of Law, where she teaches civil procedure, conflict of laws, transnational litigation, and a seminar on electronic discovery. She's a graduate of Cornell University and Yale Law School. Rhonda is an elected member of the American Law Institute. She's the author of Transnational Class Actions and Interjurisdictional Preclusion, and numerous other articles on class actions, jurisdiction, and interjurisdictional preclusion. And my first question to you is to explain for me the meaning of this last term. And we would be glad to hear your lecture. Thank you.
Good morning. Excuse me. I'm grateful to Rabia Assi and to Ariel Flavian for inviting me to participate in this morning's, the next 2 days conference, and to the sponsors of the conference, and to Dean Barzilai and everyone else who's responsible. Thank you. When Ariel asked me last week if I would fill in this morning's panel for Arthur Miller, I was reluctant to do that. His shoes are very big to fill, and initially I declined the opportunity. I did agree to provide a bit of background on American class actions. So for those of you unfamiliar with the American class action tool, this will be a brief introduction and hopefully a helpful refresher to those of you with some familiarity. My plan this morning is to introduce American class actions by focusing on 6 specific topics. First, the dual mission of American class actions. Second, the Class Action Fairness Act, what we call CAFA, and its role in shifting a great deal of American class actions into federal courts. Third, the requirements of Rule 23 of the Federal Rules of Civil Procedure, which govern the certification process. Fourth, the protections that due process assures to the absent class members when they're seeking money damages, including notice and the opportunity to exclude themselves. Fifth, the phenomenon of class action settlements and the court's role in approving them. And finally, attorney's fees in class action litigations in the United States. The American class action vehicle permits one or several named representatives to sue on behalf of a larger group of similarly situated persons. Perhaps the most distinctive feature of the American class action is its inclusiveness. Once the court concludes that the class can be certified, the class includes everyone that falls within the definition, without any affirmative action or consent on their part. In other words, it's not necessary for them to opt in. There are, in some cases, provided an opportunity to opt out. The American class action serves a dual mission. First, it facilitates the efficient resolution of many claims. By permitting the aggregation of multiple claims in a single lawsuit, the class action avoids duplicative lawsuits that would raise the same issue repeatedly and achieves a more efficient resolution of the claims. So this first mission is most apparent when the plaintiffs have what are called positive value claims, that is, claims that would be worth enough to justify the costs of litigation. So if 1,000 plaintiffs would sue separately, it's far more efficient to have one large class action that aggregates all of those claims than it would be to have 1,000 separate lawsuits adjudicating the same issues against the same defendant. On the other hand, with negative value class actions where the cost of litigation exceeds the possible recovery, a class action does not serve this efficiency mission. If none of the plaintiffs would sue separately to enforce their claims, then at least arguably it's less efficient to have a class action that brings those 1,000 claims together, because the alternative is no litigation. Those plaintiffs wouldn't sue on their own. But that's where the second mission of the class action comes into play. Even at the expense of increasing litigation, class actions empower parties to vindicate their rights under the law by pooling together a lot of small claims that would not be worth it to prosecute separately. Once empowered, class actions permit plaintiffs to seek compensation, the enforcement of the law, and the deterrence of wrongdoing by the defendant. With this understanding of the dual mission of class actions under our belts, let's now turn to see how the Class Action Fairness Act shifted a lot of class action litigation into federal courts. In the American legal system, both state and federal courts have jurisdiction to hear lawsuits as an original matter, but the federal court's jurisdiction is much narrower. Ordinarily, they can hear only federal question claims, that is, claims that arise under federal law, such as antitrust claims, securities fraud claims, discrimination claims, and what we call diversity actions, that is, state law claims between citizens of different states in which the amount in controversy exceeds $75,000. In 2005, Congress enacted the Class Action Fairness Act, or CAFA. Proponents of the act were concerned that state courts were certifying meritless class actions and approving settlements that provided class members with only coupons of questionable value, but which provided class counsel with very hefty fees. This is the part of the concern that Chief Justice Grunis raised earlier this morning. Congress believed that federal courts would do a better job scrutinizing these meritless claims than the state courts were doing. So, to ensure that more class actions would be heard in federal court, CAFA substantially broadened the federal court's original subject matter jurisdiction over class actions and enlarged opportunities for defendants to remove actions or to transfer actions that were initially filed in state court to federal court. Diversity jurisdiction is ordinarily available only in disputes between citizens of different states in which the amount in controversy exceeds $75,000. And the Supreme Court has long interpreted that diversity requirement to require what we call complete diversity. By that I mean no plaintiff can be a citizen of the same state as any defendant. And until recently, each plaintiff had to satisfy the $75,000 amount requirement individually, so class members could not aggregate their claims to meet that $75,000 jurisdictional amount. CAFA altered these baseline rules. In a new section, 1332D, added to Title 28 of the U.S. Code, CAFA granted federal courts original jurisdiction over any class action with at least 100 proposed members and an aggregate amount in excess of $5 million, as long as minimal diversity exists between at least one member of the class and one defendant. So complete diversity is no longer required, and individual class members do not need to satisfy the amount requirement on their own. As long as the claims of the class as aggregated exceed $5 million, the amount requirement will be met. So 1332D made it easier for plaintiffs to file class actions in federal court if they chose to do so. CAFA also made it easier for defendants who were sued on class action claims in state court to remove those actions to federal court. Removal is the process whereby a defendant that's sued in state court can transfer or remove a case from state court to federal court if it could have been filed in federal court in the first place. So in addition to expanding the district court's original jurisdiction to hear class actions, CAFA made it much easier for defendants to remove class actions that were initially filed in state court to federal court. While defendants sued in their home state's state court are ordinarily denied the opportunity to remove litigation from state court to federal court on the basis of diversity of citizenship, a new section 1453B permits removal in the class action context even if one of the defendants is a citizen of the state in which the action was initially filed. Ordinarily, all defendants must join in the application for removal, but under CAFA, any one defendant may remove the action, the class action to federal court, even without the consent of the other defendants. And CAFA enlarges the period of time in which removal on the basis of diversity of citizenship may be accomplished. So since many class actions are now filed in or removed to federal court under CAFA, and since many of the state class action rules are mirrored on the federal rules of civil procedure, I'm going to focus the rest of my remarks on the federal rules of civil procedure. Rule 23 of the federal rules governs class actions in federal court. In order for one or more representatives to sue on behalf of a larger group of plaintiffs, the class action has to be certified, and all four of the requirements under Rule 23A have to be satisfied. The first of those requirements is the numerosity requirement, which requires that the class be so numerous that joinder of all members would be impracticable. The rule is designed to ensure that individuals don't unnecessarily lose their rights to control their own claims. And so there's a requirement that the class be large enough that we really need a class action in order to go forward. There's no magic number that satisfies the numerosity requirement. And the geographical dispersion of class members is a factor that will motivate a court to conclude that the numerosity requirement is met, even if the number of class members is smaller. The second requirement under 23A is what we call the commonality requirement. It requires that there be questions of law or fact common to the class. And this requirement makes sense because if there weren't common questions, then it wouldn't be efficient to aggregate the claims together into a class action, and we'd have to question the adequacy of representation that someone else could afford to the class members if they didn't actually share common questions. The text of the rule speaks in terms of questions plural, which suggests that a single common question would not be sufficient. We're going to talk later in the day about the Walmart decision by the Supreme Court in 2011, which has heightened the scrutiny that courts now apply to the commonality requirement. But basically, what the court is now requiring is that there be a common contention of such a nature that it's capable of class-wide resolution. And the court is calling for examination of dissimilarities among class members that could interfere with the common resolution of their claims. The third requirement under Rule 23 is typicality, which requires that the claims or defenses of the representative parties be typical of the claims or defenses of the class. And the goal here is to make sure that the named representative is the right person to represent the class. So this portion of the rule has been interpreted to require that the representative be a member of the class, have the same interest of the class, and have suffered the same injury as the class. Finally, Rule 23 requires adequacy of representation. And this requirement is designed to ensure that there are no conflicts of interest between the named representative on the one hand and the absent class members on the other hand, and also to ensure that the attorney representing the class is qualified to do so and has the resources needed to prosecute the class action. Now, in addition to satisfying all four of the Rule 23A requirements, in order to certify a class, the court has to determine that one of the four types of class actions permitted under Rule 23B exists. The first two of these types of class actions are governed by Rule 23B1, which requires the court to contemplate what would happen if no class action were certified and to determine if adverse effects would be felt if the individual class members sued separately. So under Rule 23B1A, a class may be certified if separate lawsuits by individual class members would create a risk of inconsistent adjudications that would establish incompatible standards of conduct for the defendant. Let me provide just one example. Assume that an employer had promised its employees that upon their retirement it would fund all of their health care costs, but later changed its mind and offered only a fixed payment per retiree, which they could use to purchase an individual health care policy. Since there could be thousands of retirees who might have claims against the company, and if they were to sue separately, there would be a risk that those claims would be resolved inconsistently, with some courts holding that the employer was obliged to honor the initial promise of providing lifetime health care to the retirees, and other courts saying that the alteration in the terms was permitted. And so there would be this risk that the defendant wouldn't know exactly how it should proceed vis-a-vis the remaining class members. But if we certify the class under B1A, we can resolve all of those claims together with one resolution. Similarly, under Rule 23B1B, a class may be certified if separate lawsuits by the individual members of the class would create a risk of adjudications that, as a practical matter, would dispose of the interests of other members not parties to the individual adjudications, or substantially impair or impede their ability to represent their own interests. So the concern here is that one plaintiff might sue separately and get a judgment that would affect the rights of a second plaintiff's rights, but that second plaintiff would not have participated in the lawsuit, might not even have had notice of the lawsuit. So under Rule 23B1A, the theory is that a single class action in which all of the absentees' interests would be represented would be preferable to separate lawsuits that might have negative consequences for the absentees. Rule 23B2 was added to the rules in 1966 to make it easier for plaintiffs to bring class actions under the civil rights laws, such as against employers engaged in discriminatory practices. Under Rule 23B2, a class may be certified if the defendant has acted or refused to act on grounds generally applicable to the class, so that final injunctive or declaratory relief would be an appropriate remedy. So for an example, if an employer barred women from applying for certain positions, but it allowed males to apply for those positions, it would have acted generally with respect to the group of women applicants, thereby making an injunction against that type of discrimination an appropriate remedy for the entire class of women applicants. Now, because the classes to be certified under 23B1A, B1B, and B2 are presumed to be very cohesive, and there's concern that separate lawsuits by individual class members could have negative effects either on the defendant or on the absent class members, Rule 23 does not afford those absent class members an opportunity to exclude themselves. These types of class actions are mandatory, and even notice in these types of class actions is in the discretion of the court. On the other hand, classes that are certified under Rule 23B3 are thought to be less cohesive. Unlike members of B1 and B2 classes who may have all been employed by the same company, for example, members of a B3 class may share nothing in common except that they may have purchased the same product or may have been exposed unwittingly to the same chemical. So in these cases where the class members are only loosely affiliated, Rule 23B3 permits certification only if two additional requirements are met. First, the court has to find that the questions of law or fact that are common to the class members predominate over the questions that affect only individual members. And second, that a class action is superior to other available methods of fairly and efficiently adjudicating the controversy. The rule identifies several factors to be considered in making these predominance and superiority assessments. Since B3 classes are less cohesive than the B1 and B2 classes, and there's greater concern that they may wish to represent themselves in claims in which they have money damages at stake, Class members in B3 classes are afforded certain protections not guaranteed to class members in the other types. In a case called Phillips Petroleum versus Schutz, the Supreme Court held that if a class action for money damages was presented in a forum with which the absent class members lacked sufficient connections to be subject to in personam jurisdiction, then they would have to be afforded additional protections, including notice and the opportunity to be heard, including an opportunity to remove themselves by executing an opt-out form. As noted earlier, class members don't need to consent or affirmatively opt into the litigation, but they must be afforded an opportunity to opt out or exclude themselves. And third, that due process guarantees that the named representative will at all times adequately represent the interests of the absent class members. As Chief Justice Grunis relayed earlier, only a small percentage of class actions in the U.S. Actually go to trial. The majority of them are settled, and as he mentioned, in some cases, class counsel and the defendant actually have reached a tentative settlement even before the action is filed. But settlements that are negotiated between class counsel and the defendant must receive judicial approval. And the reason for that is to ensure that there hasn't been some kind of collusive settlement that's been negotiated wherein the class action lawyer is looking out more for his own personal interest in receiving hefty attorney's fees, and the defense counsel is interested primarily in shielding the defendant from a large judgment and ensuring wide preclusive effects for the class action settlement. And so the concern is with collusion and the risk that the class action absentees will be sold down the river. And so the court must approve the settlement. So under Rule 23E, only certified class actions may only be settled or even dismissed with the court's approval. In terms of other protections afforded under Rule 23E, there must be notice provided to the class members that would be bound by the settlement. The court must conduct a hearing to ensure that the settlement is fair, reasonable, and adequate. There is a requirement that if there are any side agreements reached between class counsel and the defense counsel, that those side agreements be disclosed. If the court was certified under Rule 23B3, the court has discretion to order that the class members be afforded what we call a back-end opt-out, meaning a second opportunity to exclude themselves from the class now that they know the terms of the settlement. And finally, class members must be afforded an opportunity to object to the terms of the settlement. Regardless of whether the settlement is settled or tried, Rule 23H of the federal rules permits the court to award reasonable attorney's fees and costs, although it's possible that some in the room may not view the attorney's fees that are approved, in fact, to be reasonable. The rule sets out the procedure for the court to approve applications for attorney's fees, but it actually doesn't describe or set out a prescribed method for calculating attorney's fees. So as the Chief Justice noted earlier, courts apply two principal methods for determining the appropriate attorney's fees. The first is to calculate the lodestar, which is determined by multiplying the number of hours worked on the litigation by each attorney, multiplying that number of hours by the attorney's respective hourly rates. And that lodestar amount can then be adjusted upward or downward depending upon the quality of the work performed, the benefit conferred upon the class, the contingency of a successful outcome, among other factors. One of the problems with the lodestar approach is that it gives attorneys the incentive to rack up a high number of hours to increase its fee at the expense of the class. The second principal method is a reasonable percentage of the recovery. Many courts in the U.S. are skeptical of awards higher than 25%, which I understand is a high percentage relative to the percentage permitted here in Israel. One of the issues that has arisen of late, and I wonder if this is the case in Israel too, is whether that percentage should be calculated based upon the entire pot of money that's potentially available to the class, or only of the portion that's actually claimed by class members, since many class members may not come forward and actually claim the amount that they're entitled to. Whether the court performs the calculation based on the lodestar approach or based upon the percentage of recovery, courts will often perform what we call the cross-check. They'll look to see the amount that would be determined applying the other method. So that's a way to make sure that the method that they're actually applying doesn't yield some number that's completely out of whack with the other method. I'm going to ask that you hold any questions that you have for later so that all the panelists can speak, but I'm grateful for your attention. Thank you very much.
Thank you, Rhonda. Sure. It was very interesting. And our next speaker, Professor Christopher Hodges. Chris is a professor of justice systems at the University of Oxford. His research is directed at reviewing all EU regulatory and dispute resolution systems in order to devise an integrated civil justice and regulatory model for European states. His books include Law and Corporate Behavior, Integrating Theories of Regulation and Enforcement, Consumer ADR in Europe, and the Reform of Class and Representative Actions in European Legal Systems. He worked from 1977 to 2003 in major city of London law firms, so you're a colleague. And with a pan-EU practice, his advice has been sought by the European Commission, European Parliament, numerous governments, regulatory authorities, ombudsmen, and multinational business and consumer associations across the world. Please, Chris.
Thank you very much. Good morning, ladies and gentlemen. It's a great pleasure to be here in this very interesting conference. And I echo the warm thanks to Ariel and Rabea and sponsors and all the arrangers of the conference. Thank you. I have rather a lot of slides. And unfortunately for you, I have two slots to speak in, one now and one tomorrow. So what I'm going to do is split them between the two presentations. The first is more or less an overview of what is happening in the EU on class actions. And the second is what is happening on other means of dealing with collective redress generally. And I don't think there's time this morning to get into the second half. I think the second half is much more interesting. And it's where things are happening, whereas things are not really happening in the first half, but I need to tell you about them. However, given the very interesting introduction by Chief Justice Grunis, I just want to raise one other issue, which is that both these two halves about saying what are we doing need to go back to the fundamental objectives. And what I think we are doing in Europe at the moment is to look at which systems actually deliver compensation and which systems deliver what used to be called deterrence. If you'll forgive the plug, because I wasn't going to mention it otherwise, I've just finished a very large book called Law and Corporate Behavior, which looks at public enforcement, and that finds that most UK regulators do not believe that they affect behavior by deterrence. Deterrence is a rather medieval concept, but what one needs to look at, of ruling by fear. And that doesn't necessarily chime with modern democratic societies. What one needs to do is to think about ethics, values-driven approaches, and other ways of achieving behavior. And that is what most of the UK regulators are now either doing or moving very close to. That has huge implications in relation to private enforcement and, of course, the balance, which I will mention, between public and private enforcement. So if you're really thinking about what are we trying to do, one needs to look at the mechanisms, but one needs to start with the objectives and then look at a lot of empirical evidence to say what actually works. That's a very big topic on which I could say a great deal, but not now, unfortunately. So let's do with something slightly more prosaic, which is the general overview about what is happening in the EU and the UK on collective redress, as we call it. The EU had a very long debate, starting off in the consumer protection area with saying we need broad mechanisms that deal with mass redress, negative value, small claims, etc., etc. We looked, therefore, at the obvious example, which was the US. Australia was beginning to explode 10 years or so ago, and many people in Europe started to get worried about the US system. It is true that at the moment, quite a number of European member states are including collective procedures of one sort or another in their national laws or civil procedures. However, the reality is that in most countries, these are very little used. There's a sequence of reasons for that. Quite a lot of them, I think, are to do with the balance between public and private enforcement and the availability of alternatives, such as regulators bringing about redress and ADR. And that's the second part of my talk. The European Commission, broadly speaking, proposed a general model in 2013. It nearly made a generic legislative proposal, but the politics was so difficult, and it's a long and complicated story, that no legislative proposal has been made by the European Commission so far. There is just a recommendation, which will be reviewed in 2017. It's a recommendation that national governments should include a collective redress mechanism of a particular model. No government has followed that model. So we have a problem. However, and I will look at one or two bits of rare empirical evidence. So there are, however, alternative things, which we'll talk about. Now, against all this, one should just mention the fact that all the debate coming out of Brussels is against the background of the slow but inexorable harmonization of European civil procedure, perhaps to create a single arrangement for civil procedure and related courts across Europe. That may take a very long time. I used to think it might take 50 years. I think it might take at least 100 years. But there's quite a lot of us who are working on aspects of it. It's an obvious thing to do if you sit in the European Commission because it's part of your objectives of harmonizing aspects of a single market. But of course, it's immensely difficult, and we don't need to go into all the difficulties. But here are a number of recent provisions. So on the right-hand side, there's those of you who know about public international law will know about the Rome I, Brussels I conventions, etc., with jurisdiction and enforcement of judgments. And on the left-hand side, a number of particular measures in relation to civil procedure, one of the most interesting of which is a directive on competition damages, which is fairly recent, because that includes some specific provisions, such as including discovery, which is a common law concept, which is, of course, somewhat new in relation to, and somewhat challenging perhaps, in relation to civil law countries. And that's a very good example of why one needs to take some time to develop what might become a European model. After a lot of debate, public debate, it's really quite surprising just how strong the statements over several years by European commissioners and members of the European Parliament were against US class actions. And this is a statement from a Commission memo of 2008, but very similar wording been used on a number of times. And particularly surprises me in relation to the European Parliament, who are usually strongly pro-consumer, strongly in favour of collective redress. Let me just read this. It's really very strong political language. US-style class action is not envisaged. EU legal systems are very different from the US legal systems, which is the result of a toxic cocktail. A combination of several elements, punitive damages, contingency fees, opt-out, pre-trial discovery, and so on. This combination of elements, again repeating the word toxic cocktail, it's very undiplomatic, should not be introduced in Europe. Different effective safeguards, including loser pays, judge discretion to exclude unmeritorious claims, accredited associations who are authorised to take cases on behalf of consumers are built into existing national collective redress schemes in Europe. So you can see a very strong political steer, which very, very broadly based, that we don't want the US system because we think it's abusive, or the leaders think it's abusive, and you need safeguards. So that's the background. In the Commission recommendation of 2013, you see a matrix. Now, one can go through this in some detail, but I won't. Anyone who knows about it will know about it, and otherwise you can just read about it. But it's opt-in, and there's a whole list of safeguards, basically. No punitive, controls on lawyers' fees, third-party funders, which are beginning to appear, some regulation in relation to what they do, and so on. Loser pays, etc. So there's a balance attempting to be struck there. One important point, and a couple of us have written articles on this as soon as the recommendation was proposed, and that is that this is not legislation. It may be at some stage in the future, but it might well not look like this. The safeguards are there to prevent abuse, and that's the official policy, that one needs safeguards. The problem is, and I think it goes exactly to support the point made by Chief Justice earlier, if you want to encourage a lot of private enforcement, you have to have incentives and liberalisation to an awful lot of private intermediaries. And if you put, quote, safeguards on them, then they won't be incentivised. On the other hand, if you put a lot of safeguards on them, therefore, the mechanism just won't work, or it will work in fairly limited circumstances. Now, what one sees across Europe is that every single existing national class action, and we had to change the rule. The European Commission changed the rules, changed the terminology, and stopped talking about class actions because we thought that was American and it confused people, and we didn't want that, and started talking about collective actions and collective redress. And collective redress is interesting because it's actually the outcome. It doesn't assume the mechanism, which is the whole point behind looking for alternative mechanisms, which are ADR or regulatory approaches. If you're looking, therefore, at all the national systems of collective redress, they're all over this side in Europe. They include a different balance of safeguards, and everyone is different. But it means that there isn't much litigation, because as a matter of public policy, we don't encourage massive private enforcement. But you can't have both. If you want incentives, you have very, very high fees, et cetera, and it's very difficult to regulate them. And on the other hand, if you control them, you won't get the litigation. So you've got to think of other ways of solving the problems of behaviour and redress. And I certainly argue that that is actually a stark problem. You cannot calibrate it, so you've got, quote, just enough litigation, so that every meritorious case will get through and no unmeritorious case will not get through. It is a classic catch-22 situation. So therefore, the really interesting discussion in Europe is what else do we do in relation to behaviour and compensation. One point about the origins of the national rules. These are not all of them, but they've appeared piecemeal over the past mainly 15 years, quite often because of a specific event in the country, like the Deutsche Telekom that Astrid will talk about as a response to, the German capital rule was a response to a specific case. Various others in France and so on were responses to specific situations. So therefore, there's a political response that might not fit a generic model that you would want for the future. And therefore, many of these, not all, are not horizontal class actions, but they are frequently to do with consumer or competition. There is continuous change. So recently, there are proposals in the Netherlands, which Stefan will talk about, and France because it's had a whole sequence of pharmaceutical and medical technology and healthcare scandals, have got firstly a general consumer class action, secondly they're about to get a healthcare class action, and there's just been a proposal from the government to include a generic one, because the national debate is such that we need to stop this. Why they need that, I do not know, because they've actually got a very good ADR, personal injury system, and those 2 points have not been joined up. In the UK, because of discussions about consumer enforcement and competition law, two actually fairly different areas, we've got a large extension on the regulatory side of bringing about redress, which I'll explain later, on the consumer side, but we've also got something which is in the competition law, which is an opt-out class action for competition damages. That's very recent. In fact, most people miss the point that there's been something else for competition law, which is a regulatory power to bring about competition damages. So there are lots of different approaches now appearing. You could have an awful lot of safeguards, and here is a list of various different types. So as I say, selections from these appear in different national laws as a result of the national debate or what the politicians thought. No national law will ever be rational because it comes out of political compromises. Sorry, I think I'm going the wrong way. Now, if you ask the question, what's actually happening on the ground, it's very easy to be blinded by the fact, 20 of the 28 European member states have now got class actions. The next question is what's happening? And it's very difficult to find out empirical evidence on that. And this is a collection that I pulled together with the support of the Swiss reinsurance company in a conference a couple of years ago. We're going to repeat it in Oxford this time next year. But what it basically showed was that there's the very, very low level of class actions in most European jurisdictions. We just don't use private enforcement and we don't use collective enforcement because we might have something else, but that varies from country to country, or nothing happens. But there doesn't seem to be too many complaints about nothing happens in most situations. There are two exceptions because that I know of at any rate, and this may be far from complete data. The two exceptions at the moment are Italy and Poland, where when the class actions were introduced, the lawyers have been very enthusiastic in attempting to bring lots of them without any great success. It's difficult to find out all the details, but the non-certification rate seems to be about 50%. We all know that if you start any litigation in Italy, it will take 10 years anyway, and a class action is going to take even longer. So what one starts to see with quite a number of countries is if you ask the question, how do we deliver redress, and how do we do it quickly, cheaply, effectively, and people getting the money they are due, the answers are not here. Because in most countries, these actions take a very long time. Unlike the US or Israel, they don't settle early because the incentives to settle and the incentives for the intermediaries to settle by getting paid off through greed or whatever you want to call it do not exist. So therefore, the litigation can take a very long time to go through, as it will in Italy and various other countries, and the original Deutsche Telekom case, for example, in Germany. You may say more about that later. And so on. So there are some interesting approaches. One other unusual approach is in the Netherlands, and Stefan will say something about that, where they've got a fairly successful, interesting approach to settlement and settlement class actions. Perhaps arose by accident, but it's an interesting approach. I'll say something about the England and Wales, just in case people are not aware of that. We've got a very long-standing 19th century representative action, which the judges decided should be interpreted very strictly. So you have to have everyone having exactly the same interest. And therefore, that might apply in landlord and tenant issues in some cases, but it doesn't apply in mass damages cases where individual causation or individual damage is different. So that one is sort of on the shelf. We do have mass consumer injunction legislation, which is not used much because there are other ways of achieving the problem, but that is all EU harmonized consumer protection legislation. When Lord Woolf modernized the civil procedure rules in 1999, he took the opportunity to include a generic multi-party action called a group litigation order, the GLO. In many ways, that was extremely minimalist and said almost nothing because it chimes exactly with other principles of the Woolf modernization of the civil procedure rules, which are based on case management and settlement. An interesting observation, a number of us are about to publish a book in which we've written case studies from around the world, and the one I've contributed is a large petrol depot explosion called Buncefield about 10 years ago. And various applications were made in that. There were different groups of householders or commercial entities who had suffered very large damage. Various groups, especially for the consumers and householders, applied for a GLO and the judges refused. The reason was they didn't need a technique, they didn't need a rule, because they could manage all of these cases. It may be in separate groups or maybe combined at different times in the process through normal case management powers that we have. And in fact, the case was passed from different judges depending upon what the issue was. So some of them ended up in the commercial court, some of them were involved in the technology and construction court, some of them were involving a costs judge at the end. But they all case managed very, very strongly and basically put pressure on the lawyers to tell them what was going on settlement. So the whole lot was resolved. There were one or two technical legal issues which the judges resolved so that then more settlements could occur. The whole lot was resolved within 5 years, which was really quite remarkable given the number of people involved. And there was huge professionalism displayed by the lawyers on every side. But it was basically case management without using a particular technique. I've mentioned the very new competition damages opt-out action. A number of law firms are gearing up to bring claims based on that. They will all be, at least for the first few years, follow-on cases. So in other words, the public authority, public competition authority, has already decided that there was an infringement. In the UK only, as far as I know, possibly in Denmark, the Public Competition Authority now has the ability, as part of the public enforcement regime, of saying, and you will pay people back, won't you? So there is, in that instance, a rather complicated procedure, which is almost designed to be difficult because our Competition and Markets Authority doesn't really like it. But it is there, and it will be interesting to see. Any sensible company will actually propose a scheme under those administrative rules in order to stop follow-on class actions because they are actually unnecessary. They may be necessary for a few years because there are some difficult substantive legal issues or issues of quantification that need to be dealt with by the courts. But a combination of those two techniques will be interesting to see. In the UK, we have seen lots of experiments, and this goes to the greed point, I'm afraid. Lots of experiments in changing how lawyers are paid in the past 20 years. When I was in practice in the 80s and 90s, there were a lot of group litigation orders, or the predecessors of that, that were paid for on the plaintiff's side by public funds out of legal aid. Almost all of them did not succeed, and the lawyers were paid win or lose. So you saw a spike of cases. Legal aid has gradually been withdrawn, and we've had various different approaches, and I won't go through all the detail about conditional fees and now what's called damages-based agreements, which are basically a sort of contingency fee, but they're very unpopular at the moment with the legal profession. So this is a graph in the past 10 years or so, 15 years, of group litigation orders that was prepared by my colleague Rebecca Money-Curl, which shows the number of GLO applications in the UK. And you can see they've just about died out. And that is, if you want to be either cynical or objective about it, that is simply a function of lawyer funding. It may be a function of what else is out there that is not solved, say by other mechanisms, and that would be difficult to prove either way. But the fall-off is to do with lawyer funding. There's a slightly more embarrassing issue because one ought to say what are they about. So we don't see the cases that they used to be about, which is pharmaceuticals or tobacco products. And we don't see in that list the ones that they will be about, which is cartel damages, because that's only arisen on a European basis fairly recently. We see some environmental ones, like Buncefield, although that wasn't a GLO. We see an embarrassing amount of child abuse because that was an issue that was becoming public at that time, and there were criminal prosecutions starting off, so obviously the criminal and civil side went in tandem. But things fall off. Now, if you therefore ask, why does Europe not have anything like, as in Israel or Australia or the US, a thriving private enforcement or class action mechanism? That's an interesting question. It may be to do with lack of adequate funding. It's clearly to do, therefore, with the application of safeguards, if you like. In other words, a non-liberal approach to funding and costs rules. It may be to do with much broader features about culture in relation to the relationship between public and private enforcement, or something else. Now, the something else bit, I think, is extremely interesting, because in the something else bit, you find ADR and regulatory approaches that work and work extremely well. So if one goes back to the criteria of something that delivers redress, also delivers behavior control, quickly, cheaply, effectively, people get what they deserved, you need to look, I think, in the something else box. I used to call this a three-pillar model, and I now call it a four-pillar model, because I used to think that the issue was the distinction between public and private enforcement. But actually, it's the something else that is interesting. So if one moves in from private litigation, you have an ADR pillar. And broadly speaking, what we have done is not just extend mediation and ADR within the court system or before the court system, but in Europe, we've created specific architectures for ADR. So I'll talk in the second part about consumer ADR, which have got their own architectures, which are consumer ombudsman, for example, that are part regulatory, but also very, very effective and very quick in the countries where they exist so far at resolving individual or mass consumer disputes, and certainly involving small problems. And if you move in from the public regulatory side, one has to look at self-regulation and therefore co-regulation. So certainly in the UK, we've developed sophisticated arrangements, which are being extended by the government now, in relation to collaboration between public regulators and companies and trade associations and anyone else, about saying, let's deal with behavior, including behavior after things go wrong. In other words, how are we going to deal with redress? So you give regulators, and I mentioned an example from the competition sphere, but there are much better examples in other sectors which work much more better. You give regulators what you might call regulatory redress powers as part of their general toolbox, and they just say, here's a proposal, or you make me a proposal and I'll approve it, before we deal with all the question of sanctions and behaviour, etc. So therefore, the relationship between where you get consumer ombudsmen working together with consumer regulators, then it's very efficient indeed. And we've got examples of that in the UK. Now, I'm going to stop there, slightly tantalisingly, before telling you what I think the answers are that we've discovered, but you'll have to wait till tomorrow afternoon. I would just make one final point, and that is that in the consumer side, this is quite extraordinarily foreseen by Cappelletti when he was looking at access to justice. And he said there would be 3 waves of consumer access to justice. Private enforcement and class actions would be in there, but actually the ultimate 3rd wave would be ADR. And what we're now doing in Europe is developing ADR in a specific new architecture. Thank you.
Thank you, Chris. And our next speaker is Professor Alon Clement. Alon earned his LLB in law and BA in economics in Tel Aviv University. After practicing law for several years in a private law firm in Israel, he continued his studies at Harvard, where he earned his SJD degree. In 2000, he joined the law faculty at IDC Herzliya, where he founded the class action clinic. And in 2015, actually this year, he joined the Tel Aviv law faculty, where he gives classes in civil procedure, class actions, and law and economics. Alon writes on various subjects in the field of civil procedure, law and economics, and law and social norms. And he specializes in class actions, and most of his articles relate to this field. Alon, your turn.
Thank you very much. Yeah, I have it. Yeah. So this is a picture of my new home, Tel Aviv University, which I'm proud to be part of now. I'm going to talk about Israeli class actions. Some of the audience here, the Israeli ones, have already seen some of those figures or have read our report and the following papers on those findings. But as part of this marvelous group of world expert on class action and collective redress, I think this serves as some kind of a comparison for us for the further discussions that we will have today and tomorrow. Before I begin, I must address one thing which, I think there may be a common theme throughout this conference, and which was raised by Chief Justice Krunis, and that's basically the question: what would we like to motivate regulation or private litigation, whether it be a moral motivation or an economic motivation? I wouldn't call it greed, but I would call it economic motivation. And I think there's a good question there, and everyone knows that the sentence, the road to hell is paved with good intentions. So good intentions or moral intentions may lead to bad outcomes. Economic intentions sometimes may lead to good outcomes. Our research was more analytically meant to examine whether the Israeli class action law actually realizes the goals that were set in the law and by the legislator. And that's what I'm going to talk about. So basically, I will talk about, I'll say a few words about the social objectives and costs of class actions. Then I will give some brief legal background, because the Chief Justice has already mentioned some of it, on Israeli class actions. I'll tell you few words how we collected the data, and then I will present the basic findings that we have there. So I don't think, although I intended to talk a bit more about the social objectives, I think basically we all understand, and the Israeli law, the class action law, actually specifies those objectives, but basically what we're thinking about is collective access to court, compensation and law enforcement and deterrence. Those are basically the goals of class actions. And so I want to say a few words about the costs. So what are the costs of class action? First of all, there are the litigation costs, right? The litigation costs of plaintiff, defendants, and courts. Now, you might think that class actions may reduce the costs in the litigation in the judicial system, but that would be only if they substitute for other litigation, right? If they substitute for individual litigation and aggregate them in one class action. And as I will say in a few minutes, this is not the case in Israel. So basically, class actions in Israel add to the cost to the overload over the judicial system. So this is one type of cost that we have to take into account. Another type of cost we have to take into account is that, to some extent, on the one hand, class actions facilitate collective access to courts, but that may come at the price of individual access to courts. And we may care about that if the individual, in those cases in which individual access to courts is important, namely those that whose individual importance or individual value is higher. Again, those are not the cases we see in Israel, but this is another cost that we have to think about. And of course, precaution costs are some costs that are taken. They should be taken, but those are the costs that we have to think about when we're thinking about the goals, objectives, and the cost of the class action, because they are going to drive precaution costs to be higher. So what we have tried to do, we have tried to look at the data and figure out to what extent have the Israeli class action realized those goals, and what are the costs that they have imposed on the Israeli legal system. One thing I should say is that as far as compensation is concerned, and I will show you the data, you can easily measure how much compensation was paid in class action. I mean, you can easily think or have some idea. But as far as deterrence is concerned, it's much more difficult to measure. And therefore, the question posed by the Chief Justice, whether anyone actually studied whether class actions have a deterrent effect over corporate and public authorities, I think many people have tried, but I think with little success, both in the US, and we're thinking about it here in Israel, but we don't have any real idea about to what extent such an effect has actually materialized. As I will show you, I think mainly what we see is a regulatory goal realized through class action, and less deterrence goal realized through class action. But this is so when you do empirical research, there are some things you can measure, some other things that you cannot measure, and deterrence is one thing which is very, very difficult to measure. Very difficult to measure, and again, we're thinking about it, but I will not show any results because I don't have any. So a few words about the Israeli class action law. The Israeli parliament enacted this class action law on January 1st, 2006, and the law superseded all previous statutory arrangements which allowed class actions. So Israel actually had the class actions since the 1990s, but some changes were made in the class action law, which I won't go into detail. And basically, what we have now is this class action law, which is modeled, again, basically after the American Rule 23, the Federal Rules of Civil Procedure, Rule 23. So this model basically consists of three basic features, which are, first of all, we have a prior certification stage. That is, you cannot just file a class action, you have to certify a class action, and only then can you conduct it. That's the first pillar of Israeli class action. Second, it is lawyer-driven. So, as you can understand by now, lawyers are the ones who are driving mainly most class actions, and in Israel, lawyers are compensated out of the common fund if it is created, or as a fee shifting if no such common fund is created but an injunctive relief is awarded. And third is that we have an opt-out regime, that is class members. The class includes all class members who have not opted out of the class, and it is very rare for class members to opt out of class action. So those are the basic features of Israeli class action. As far as certification requirements are concerned, again, it's very similar to the American, but still I want to mention them because there are some differences. So first of all, who can represent the class? So who is the possible class representative? One of them is the class member who can represent the class. Another two alternatives are any non-profit organization can represent the class, again, subject to some qualifications. And there are some governmental authorities, especially in the fields of anti-discrimination law, that could represent the class. As a matter of fact, most class actions in Israel have been filed by class members. In the period that we have studied, 2006 to 2012, less than 20 were filed by organizations, non-profit organization, and none was filed by a governmental authority, and this is something to note. Unlike the American class action, which is transsubstantive, the Israeli law has a list of causes of action, and only those causes of action within them you can file a class action. I will review them, basically will show you the very broad list of class action, causes of action, but still this is not a fully transsubstantive class action regime, and again, that's different from the American law. The other certification requirements include, like the American law, that we have common question of fact of law, and that basically that the class action would be an efficient and fair way of resolving the dispute, and that the plaintiff and the representative can show and demonstrate adequate representation and good faith in filing the lawsuit. One thing you should note, though, is that in Israel, a class representative must also show that she has a reasonable likelihood of winning the case, which is, again, those are some development in the US, but basically this is not like the US law. So you have to show that you have sufficient probability, enough probability, or large enough probability of winning the case in order to have the case certified as a class action. So what we did is something which is, I think, uncomparable, obviously outside the United States. I think there are some studies in the US, some studies in Australia, but not too many comparable outside of that. Because what we did, we coded all class actions that have been filed 2006 and 2012. We are now just doing the second stage, by the way, which is 2012 and 2015. And all the lawyers and judges who said to us that, you know, that used to be in the past and now it's different, we're going to show them that's not exactly true, although I haven't seen the data yet, but that's what I suppose will happen, because none of them, you know, were expected before. But basically, we coded all class actions in this period, and we had altogether about 1,400 cases resolved, but we had 2,000 certification motion and about 1,400 cases resolved. For each case, we coded 200 variables pertaining to the parties' characteristics, case resolution characteristics, and representative, plaintiff, and lawyer compensation. So this is a huge number of variables coded for each and every class action. We also have a comparison group because we had the advantage, by the way, again, with the approval of the Chief Justice. Here we have a comparison group, a study that was conducted for similar cases, a random sample of civil cases heard during the same period in Israeli district courts, so those are the courts that handle class action, and the comparison provides a point of reference to the findings and was intended to facilitate a deeper understanding of the costs and benefits of class actions as opposed to ordinary litigation. So this is the steep rise that we see in the number of class actions filed in Israel. We have another study now trying to figure out, what are the reasons? How come we have such a steep rise? This is amazing. I mean, in terms of, if you think about it, this is something that, a new legal device is adopted, and within 6 or 7 years, it is really booming. And you can have lots of explanations about them, and we can go into that maybe in further talks. But basically, this is, I think, an amazing thing. And the number we currently have, we heard from the Chief Justice, is uncomparable in the world, except for the US, and the per capita or per person rate is higher than the US here.
Do you have the number for 2014?
No, I just heard from what said. I know it's on the rise, but basically what we see some kind of an S shape. So it's not rising as steeply, but it is still maybe on the rise. We should have the numbers once we move to the second stage, as I said. So what are these class actions about? So basically what we did, we categorized the Israeli class action into 5 categories. One is consumer class actions, which include all class actions filed against businesses, insurers, and banks. So these are consumer. The second category is what we called corporate claim, in which we grouped corporate securities litigation as well as antitrust for reasons that I won't go into. The third category is claims against the governmental authority, which is very unique. And again, I won't go into that here, but unique to the Israeli class action law. The fourth category is employment and civil rights claims. And the fifth category is environmental claim, which to some extent is similar to the mass torts class action in the US. When you look at the distribution of class actions in Israel, they are very different from the United States distribution. So on the left, you see the Israeli one. On the right, you see the US ones. Israel has 78% or about 80% consumer, what I said are consumer class action, which consists of only 25% of all class actions in the US. Two important or two significant categories in the US are the corporate, as I defined them before, a class action, and the employment class actions. Both of them consist of about, together, about 40 or 50%. In Israel, we have about 2% of the class actions are securities or corporate class actions, as I said, and 4% are employment class action, which is a very small percentage of overall class actions. So Israeli class actions are mainly consumer class actions. They are mainly small claim consumer class actions.
But and this figure is based on number of cases filed, not on value of
not on value. This is based on the distribution of cases. Yes, I'll show you the further characteristics of those cases in a minute. Basically, that's what we see here. When we look at the certification requests, what do we see? I won't go into all this table, but first of all, if you want to, you can see obviously that most of the cases are filed against companies. We also have the distribution between public and private companies. Obviously, governmental lawsuits are against the government, and the government is also involved in lawsuits that are employment and civil rights lawsuits and environmental lawsuits to to a lesser extent, of course. Most of the cases include a monetary remedy, request monetary remedy, and about half of them include also, or most of them also an injunctive remedy. So the median total compensation requested, those are the numbers here again by category. And those are huge numbers. Okay, those are a huge number. There are 36 times the average that, or the median amount claimed in ordinary litigation in the same courts. Again, those courts are for cases that are filed for 2,500,000 shekels and above. So we have 36, the amounts requested are 36 times higher, but obviously when you look at the outcomes, they are not higher at all. So the outcomes are about the median ratio between the total compensation requested, the median ratio between the total compensation requested and the actual amount delivered is 18, 1 to 18. So it's 1 to 20. So basically, that's the median ratio between what is claimed. So the 5%, so this is about 5% that's actually delivered from what is a claim. So this is something that tells you what significance should we give, if at all, to this number. And it was mentioned, we don't pay any court fee for filing a class action, and therefore we shouldn't be surprised that those numbers are so high. So how are those cases resolved? Basically, those cases, 70% of those cases end by either voluntary dismissal or settlement before class certification. Okay, so this is like the huge, the highest ratio of cases, or most cases, most of the action is before certification. So the court in those cases does not deliver any decision on whether to certify the class as the case as a class action or not. And again, about 60% are resolved as a voluntary dismissal, and 15% as a pre-certification settlement. The number of cases that go after, that are resolved after certification is minuscule, none whatsoever, and 8% of the cases are resolved by a rejection of the motion to certify the suit as a class action. There is another 6% of governmental cases, which again are resolved before certification, but that's due to the specifics of this type of class actions in Israel. This is some kind of a distribution of what happens in what are the awarded remedies. So when we see remedies, what are they? What do we actually see there? So first of all, you can see the number of claims in which some remedy was awarded. Those are not mutually exclusive, so some of the cases have some of those remedies awarded, but those are real numbers. Those are not percentages, of course. So 49 cases had monetary compensation, 72 discount or coupons, Cypher donations, 96. And then those numbers, injunctions or declaratory remedy, and look at this number on the right, because I'm going to address it in a minute, 176 cases, the defendant, either a governmental defendant or a corporate defendant, actually said, you know, I will satisfy my duty. So I didn't do that before, but now that you filed the class action, I'm going to do what I was asked to, or requested to do. And therefore, this is a remedy which is very prevalent here in Israel, and it gives some social benefit. Again, maybe limited, but that's some social benefit that we see. Monetary compensation, the remedy value, the average remedy value is about 4 million, and the median is 1.5 million shekels. So this is 1.5 million shekels. This was, this would make American lawyers laugh, right? Because 1.5 million shekels is about what? 400, let's say 500,000 right? These are numbers that are, so one thing you should understand, I think, that, everyone, every time I present this here and abroad, is that even though this is very similar, the scales from here and the US are so different, and this is, I think, something that drives the differences between the Israeli and the American law. When you look at discounts or coupons, the numbers seem higher, but as you said before, a big question, and I have some indication about it, is how much of these coupons are actually realized. And the few cases that we see, that we have seen, the ratio of realization is always lower than 20%, some of them even less than 5%. So even though you see this number, the actual, even if you have the right evaluation of the value of the coupon, still the rate of realization is really much lower. So this number is totally misleading. And cyber donation. So this is something which is now very controversial in the US, and it's also some kind of controversial in Israel, although it is part of the Israeli law, unlike in the US. And those donations basically, again, you see the average amount is not so high, 300,000 shekels, and the median is 90,000 shekels, which again is not so high. And I want to, again, refer to those numbers of cases where we had injunctive relief and defendants satisfied their legal obligation, because as I will claim in just a few moments, I think this is the main benefit that we can actually point that the Israeli class actions have realized. So we don't.
How did you get the number of coupons realized in different cases?
We just have them because we're just involved in some cases, but not, so I have like 6 or 5 or 7 cases. So I don't know the actual number. I can't give you the statistics. I just give you an indication that I have about it. We try to find that, but it's very difficult. By the way, the reason it's difficult to know is because courts are not mandating reports, or at least 2006 to 2012. We'll see what happened in 2013. The judges here are smiling to 2015. But courts have not mandated the reports of how much was realized. And another thing, the attorney fee was not contingent upon realization of the coupons. So this is changing. We're trying to change it by, groundwork. Something is happening to the. Someone doesn't like my presentation here. So this is what we have. I don't know what. Okay. So now you cannot see anything here of the presentation. I don't know what. Which is it? Here? Okay. Okay, thank you. So, okay, what do we know about the compensation for representative plaintiff and attorney fees? Well, unlike common belief, and unlike what may have appeared from the Chief Justice's presentation, plaintiff lawyers don't make so much money from class actions. By the way, I think defendant lawyers probably make much more money from class actions, but plaintiff lawyers don't make so much money out of class actions. Some of them, in some cases that tend to be reported in the news, are high, but basically you see the numbers. So, and I'll mention something here, but basically when you look at, attorney's fees, so attorney fee for settlement before certification is, let's say, 200,000 shekels. This is not a huge amount. No one gets very rich from that. I know. Defendant lawyers always, when I show that, they raise their eyebrows and say, "Oh, I know. I don't have the numbers for their." But anyway, that's the number. What's very interesting and shouldn't be, what's counter any normative way we want to see to think about class, about attorney fees, is that when you look at the judgment, the average, of course, there's a small number, so there's a problem with this number, but the average payoff in judgment is lower both in terms of actual amounts and in terms of percentages, which is totally ridiculous when you think about it, because both as far as I think about it, because both as far as input considerations are concerned and as far as output considerations are concerned, this is not the way you should see. We run, I won't bore you with this, but so we run some regressions on that, and I've just mentioned what we see from the regression. So basically what we see from the regressions is that the mere fact that you go to certification, okay, you see the minus sign here? The mere fact that you go to certification reduces your fee amount. So if you go to certification, it will reduce your fee amount, whereas if you do something before certification, it will raise your fee amount. This is something which is problematic, I think. And one more thing that I want to show you is that voluntary dismissal, of course, reduces your amount, but if you look at the percentage that you get, if there is a remedy awarded in the voluntary dismissal, the voluntary dismissal gives you a higher percentage fee as compared to any other way of resolving a class action. So this is a problem of how of the way class actions are handled. What about the cost side? Well, this is again not from this specific research, but this is another research done by the research department of the courts. So this is the time, the average number of hours invested in an ordinary case in the district court. Again, those are the district court cases, and in a class action, it is separated into case preparation, hearing, etc. And of course, as you can see, interim decision, this is the gray part here, is very large in class actions if they go through all the stages. Now you might say, well, many of those cases end much earlier, right? Because I showed you most of 60% of them end with early dismissal, but still each such case requires about 3 to 4 to 5 hours on average, and that's of court time, and this is not including the time invested by defendant lawyers and plaintiff lawyers. One thing I want to say, so here is a very good point to mention one important thing about those dismissals. I said 60% are ending by voluntary dismissals, but out of those 60%, about two-thirds of those 60% are cases where the plaintiff said, you know what? The case is not as good as I thought, I withdraw. But a third of those cases includes cases in which the defendant says, you know what, I'm changing my behavior, there's no reason to progress to pursue this litigation any further. So it's not true that 60% of the cases provide no real social benefits. Two-thirds of them are total waste, but one-third gives something. And this something is, as I said before, is some kind of regulatory enforcement. Now, if you ask yourself how valuable is this regulatory enforcement, you should look at what is the alternative, that is the public regulatory enforcement that is actually conducted in those fields, mainly in consumer regulation, consumer cases, and you see that there's almost none. So basically what Israeli class actions are delivering, they are delivering a private mean of regulation. Whether this justifies their costs or not is a question. Whether this is the right way to pursue regulation is a question. And I think a very important question is whether you want to see more deterrence and compensation delivered in class action. And you would see that if you would see class actions in the other fields, not consumer class action, but corporate class actions, employment class action, and environmental class action, because there you would expect the deterrence value would be higher. The way it is structured now, but small percentage of cases are filed, and there are lots of reasons to that I won't go into. So just to conclude, 6 years after its enactment, the class action law has generated a significant amount of class action litigation. However, our findings indicate that its success in realizing its goals is limited. The law's main contribution lies in facilitating some regulatory enforcement, as well as potentially low level of deterrence, mostly in consumer law and in restitution lawsuits against government authorities. Yet, during these first 6 years, that was 2006-2012, the class action law has failed to produce a significant amount of litigation in important categories, as I said, of corporate, employment, and environmental lawsuits. The cost of class action during these 6 years was not insubstantial, and their litigation consumed resources by plaintiff, defendants, and courts. Moreover, about 1/3, as I said, of the cases were recognized by plaintiffs as having no merit and were thus voluntarily dismissed. These cases produced a net social loss. In order to improve the benefit-cost ratio of Israeli class actions, courts should take steps to encourage filing in categories that may provide significant social value: deterrence, compensation, and access to court. At the same time, courts should better screen and discourage frivolous lawsuits, and these policy goals may be obtained using procedural mechanisms that do exist in the class action, in the Israeli class action law. The Israeli class action law is actually a marvelous law in terms of its institutional design. It's very well built, but it's not, I think, well practiced still. I think we've improved by the courts. So those policy goals may be obtained using the procedural mechanisms of class certification, settlement approval, attorney fees, and plaintiff compensation, as well as cost shifting, as the Chief Justice was mentioning. Our findings indicate that court practices, at least 2006 to 2012, in implementing these mechanisms, did not always conform with principles that would guarantee the effectiveness of class action and would generate greater net social value from the class action law. Thank you.
Thank you, Alon. It was very interesting, and I would like to go now to the last part of our panel. And as a litigator, I prefer to call this next stage cross-examination, if you don't mind. And let's start with you, Chris. Class actions and derivative suits play a significant role in both the US and Israel in corporate and securities matters, breach of duty of care, duty of loyalty, dividend distribution, going private transactions, hostile takeovers, and so forth. What are the main mechanisms which replace private enforcement in EU countries? And do you believe these mechanisms can and maybe should be adapted both in the US and in Israel?
There are many. Isn't that on?
You can go over here.
There are many mechanisms. I wouldn't say whether what you should do in Israel or the US or anywhere else. This is not the imperialist approach to modern legal transfer, because one knows, apart from anything else, of not knowing the local situation, in which one needs to look at a huge amount of detail, that legal transfers frequently get mistransferred and apply in different ways. However, 2 points. One is that I'm just reading Professor Jack Coffey's book called Entrepreneurial Litigation, just published, and he, if I remember correctly, he says that derivative actions in the US peaked and fell off, and he says that many other types of cases are doing the same sort of thing over time. And the reason why derivative actions fell off was because there was another mechanism called independent non-executive directors on boards of companies. Now, whether that's true or not, because he doesn't seek to go into that, but that would certainly fit. So that is one mechanism that exists in the UK, together with a very large number of others. So we have had, for example, the takeover code for a very long time. There's a lot of soft regulation. There is a lot of background with public regulation in relation to advertising, misstatements, all sorts of other things, reputational factors, very strong. So in other words, there's an awful lot you can do, and indeed there was a report done by one of my colleagues, Professor Paul Davies, a few years ago for the Treasury in the UK, saying, what should we do about misstatements? And he said, litigation is hopeless. It doesn't control any behaviour at all, so we're not going to do that. We will strengthen the existing self-regulatory, co-regulatory, or other mechanisms, and deal with things in different ways. So the answer is, there's quite a lot of complexity if you look in other systems to achieve exactly the same end. So we just don't see any particular need for people to complain about the fact that shares go up as well as down. What you're really interested in is what's the behaviour of the lawyers, the accountants, the professionals, the directors, etc., involved in the situation. And there are a lot of controls which you can have. We've had concerns that the self-regulatory approach is not strong enough, so therefore it's been strengthened at various times. But those are the mechanisms that appear to work in our context.
And to you, Rhonda, we all know that the costs and the exposure associated with class actions may lead companies to settle rather than place their companies at risk. One of the ways to reduce exposure, at least in the US, in consumer protection cases, is to adopt what we call an arbitration clause containing a class action waiver. Can you give us your thoughts and the position of the US Supreme Court on this matter?
The Supreme Court has approved the use of class action waivers, and
only in consumer protection cases, or
well, no, not exclusively in consumer protection cases. There was a case involving a federal antitrust claim brought in the business context by businesses against American Express, claiming that American Express's they tied certain practices they tied certain products with other products, and the businesses that processed American Express charge charges claimed that American Express was violating the federal antitrust laws. Mm-hmm. But because it would have been so expensive for the businesses to prosecute the antitrust claims individually, they wanted to proceed as a group, but the agreement between the businesses and American Express contained one of these class action waivers, and there was some hope that the Supreme Court would view the clause as unenforceable since it interfered with the prosecution of federal rights secured by federal law, and the Supreme Court nevertheless upheld the class action waiver. So there's certainly I don't want to say widespread concern, but deep concern among some that the Supreme Court's approval of the practice and its conclusion that the Federal Arbitration Act preempts state law, which seeks to regulate these class action waivers, will result in corporations increasing their reliance upon these clauses and immunizing themselves from responsibility, not only to consumers, but also to employees and to others. So I think it's an issue of huge concern.
And your position on this matter?
I thought I made that clear. No, I think it's a huge problem. And it's something I'll talk a little bit about later in the day, but I think that given the Supreme Court's role in giving these class action waivers the stamp of approval, I think that we're going to need to look to Congress or federal agencies to legislate or enact regulations in the area, and there's very limited hope right now on that front. Okay. Let's hope not.
I agree. And to you, Alon, settlement agreements are relatively popular in Israel, especially after the certification stage, but are sometimes reached even before this stage, as we mentioned, sometimes even prior to cross-examination. First, I would like to know if you support this trend, and do you think one should reduce the incentive of the parties to enter into a settlement agreement at any early stage? And if so, how do you suggest to do so?
I think the incentives there are already there to settle prior to certification, because for the plaintiff lawyer mainly, he's saving those risks of not getting the class action certified, and for the defendant is serving the risk of certifying the class action, and that's most important, they both can present to the court a settlement which seems to be to the benefit of the class and which seems to be appropriate, but actually gives not insufficient remedy to the class. And as I showed you, the coupon and the cyber remedies are sort of driving part of it. One thing you should do, and I will talk about it more maybe in the closing session, is you must calibrate the attorney fee properly. It cannot be the case that the attorney fee for settling early would be both in terms of actual value and in terms of percentage higher than what you get if you get to litigate the case through. Because once you do that, you have too much incentives in having the case settled too early. The other thing, you must use the institutional mechanism built into the class action law, like the examiner that the Chief Justice was talking about before. You must have them properly employed in the class action. One thing I should say, I'm not against early class action settlement. I don't think so. I don't think that each and every class action should be litigated to judgment. And I also think that if you structure things right, even settlement class action could be okay. But you have to be very careful about it. You have to have full disclosure. You have to have monitoring mechanisms in place. And it's very difficult to actually implement, and the US experience attests to some of the problems that might arise. So I'm not against this, I'm just saying that the incentives are not built correctly right now here.
Okay. So now it's your turn. Any questions from the audience? Asaf?
I'd like to ask,
There is a handy mic.
I'd like to ask Professor Hodgkins. You said ADR is more effective. Is there any hard data regarding redress to consumers through ADR in the United Kingdom? What is this statement based upon?
Yes, wait for my presentation tomorrow.
Okay. okay, fine.
You have to come here tomorrow.
Yes, and if I can have another question to Alon. Alon, you discussed the discrepancy between the fees. Discrepancy between the fees before certification and after certification, and I would like to hear your opinion regarding the fees in Supreme Court. We had two cases, Sapir and Fatal, whereby there was not only certification but a final decision in the class action. The lawyers' fees were whatever they were, and they were cut by 50% when the appeal went up to the Supreme Court. So thereby the lawyer asks himself, why should I take this class action and deal with it for the next 5 years if at the end of the day the Supreme Court is going to cut my fees by 50%? So I would like to hear your opinion upon this.
The Chief Justice is here. I'm not going.
He's already, emeritus. You can say whatever you like.
I noticed that, but still, I am. Well, I'll just put it broadly. I'm very critical of the approach taken by the Supreme Court, not only to this, and that actually has to do some with the Supreme Court under the Chief Justice Krunis as well. I think that district courts are making a real effort and I'm now talking about settlements. District courts are making a real effort to control settlements in a way that would produce high social value, and they are really, making a very good job. So currently the district court judges that specialize in class actions are really doing a very good job in using all those mechanisms. I think it is as a matter of fact, I think that once those cases are appealed to the Supreme Court is too quick to certify settlements and to try to resolve those cases in ways that don't follow the way we want the incentives to build in. You mentioned one way of that, and that is cutting the fee. I'm not sure whether that has, that is true empirically over all cases. I don't know about that. Maybe some of them are reduced, some of them are not, I don't know. But basically,
we haven't had any case in the Supreme Court whereby the Supreme Court judges have only one case that upon appeal they have enlarged the fees, and on all other cases they've been cut.
No, but that's not the question, because the question is, how are they resolved when you don't get a final decision? Most of them are resolved by settlement in the Supreme Court, which to some extent, again, I want to be careful here, but I think in some cases overrides the district courts in ways that undermine the built-in balances that are in the law. And this is, to me, what you mentioned is not, to me, the main problem. To me, what I just said, to me, this is my impression as the main problem, because district courts are doing things right, and to some extent, obviously, the Supreme Court is reversing them, not always with decisions, but in driving those parties to settlements that are not always satisfying the public objectives of class action.
Any other questions? So thank you. And now it's, what next? Lunchtime. Thank you.